All right. Good evening, everybody. Today is August the 20th, 2024, and this is Tad, and I'm with youhavetheright.com, and tonight we also have Donnie with us. And Donnie is the one that developed the Cash In on Bad Credit system, where we have a course that shows you how to remove negatives from your credit report and get paid for it by suing lenders in small claims court. So, hey, Donnie, thanks for being here.
I am here, yes.
Yes. All right. So we're going to get started tonight. We are going to talk with Sam. And Sam went through our program and got some amazing results, and he agreed to share his experience with all of you, and it's amazing. So, Sam, hey, buddy, welcome.
Hey, welcome. Thank you. Thanks for having me.
You bet. So, you went through our Cash In on Bad Credit course at youhavetheright.com, is that right?
That is correct. I sure did.
All right. Well, why don't you tell us your story? Why don't you tell us what happened? Start to finish.
Yeah. Yep, start to finish. Okay, well, like probably everybody on the call, I ran into this information. I listened to the video that they had put out. I was a little bit skeptical, maybe a lot of bit skeptical, but I had tried so many different things in the past. Hiring people to do this for me, things like that. Spent a lot of money trying to get people who said they could get this taken care of for me who never did. The people would end up sort of disappearing or stop returning my calls, or in one case, I had hired somebody who I've essentially been paying $100 a month to for forever and ever, and they're supposed to be suing the consumer reporting agencies, and there's still not a lawsuit filed. So I was getting frustrated, and I ran into these guys, and it gave me just a lot of hope, honestly, and it made a lot of sense to me. So I watched the video a couple times, took a lot of notes, took some of the information that I would listen to or that I would hear in the video, and search that information in my own state, which happens to be Minnesota. And I'm like, you know what, I'm going for it. So I started learning how to file a small claims court, or in my case, in the state of Minnesota, it's called conciliation court. It's the same thing. And so I studied up on that a little bit. Not very difficult to do whatsoever. Just search your state conciliation court or small claims court. You find all their information, and they tell you what you can sue for and stuff, and they provide you with all of the instructions on how to do it. So I spent some time. That's probably the hardest part about any of this, and it wasn't that hard at all. I think it probably took me maybe a full day to really study how to file the claim here in Minnesota. And so what I did, so their recommendation was that you send out a notice of violations, give them 30 days, if I remember correctly anyway, correct me if I'm wrong. And then when they do or don't reply, then send them a follow-up letter. So basically you have your ammunition for small claims court. Well, I didn't do that. I sent out a violations letter. I gave them 10 days to respond. On day 11, one of them actually did respond, but, just kind of gave me the typical responses that they give. Oh, real sorry about this, blah, 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 on day 11, yeah, and so there were two of them that I sued at the same time. To me, it didn't look, I figured once I figured out the small claims court process, the rest of it's really easy. So suing two people at a time, two companies at a time, in my mind, wasn't that big a deal. So I sent out two violation letters. I gave them 10 days to respond. On day 11, I sued them. In my state, it's called a statement of claim. It's the same thing as a summons. Really easy to fill out. I took the exact verbiage that these guys provided, and that was my statement of claim or my summons. In the state of Minnesota, you don't even need to hire a process server. So all I needed to do was send that summons to their registered service address. And so probably every corporation, maybe not every, but most corporations, when you search them on the business, on the Secretary of State's website, search a business, and then you click on the information, they have a registered service address. That's where the summons goes to, the summons or the statement of claim. So that was really easy to find. So day 11, I sent out the summons or the statement of claim to both parties via via certified mail. And then, so one of them was a collection company that claimed I owed them $40,000, and another one was the original creditor that they had charged off a $7,000 debt. So two of them, same time. Within 1 week of sending that, I got a call from an attorney, and it just so happened that both of them hired the same attorney to work this out. And in that initial call, basically the attorney was like, "Yep, we're just calling to make sure we understand what your demands are. We'd like to work with you and avoid going to court on this. We'd like to settle." So I gave them what my demands were. In the lawsuit itself, I had demanded $4,000. So in the state of Minnesota, the maximum for a consumer-related small claims court case is $4,000. Now, CAD's telling me that that's not actually true. It doesn't apply to consumer reporting. So I'll have to verify that for the next time I do this. But in my case, I asked for $4,000. But when the attorney called me, he asked me what my demands were. And, I was still a little skeptical on whether this was going to work. And I was skeptical about whether or not the attorney was being forthright with me, or was he just pulling my leg and making it seem like they were going to work with me on this. So I decided at that time to, instead of asking for any monetary damages, to just ask for a deletion. And the reason I did that is a couple of different reasons. One is I'm a licensed mortgage loan officer. And these accounts potentially were going to affect my licensing. And in fact, the NMLS, the mortgage licensing service, they wanted to reorder my credit report and confirm that I had resolved these accounts, either by agreeing to a payment arrangement or having paid them in full or something like that, right? So this is a big deal for me. I've been doing this for 31 years. It's how I feed my family. And so this was a really big deal, and it was very stressful for me, the whole situation. Not the part of actually filling out the paperwork, sending in the summons, none of that was stressful. The stressful part for me was just the idea of potentially losing my license and losing my living
livelihood.
My livelihood, yeah. So anyway, so the attorney called, and so I kind of had that in my mind at the time. I was still not 100% sure. It was my first time doing this, and I hadn't heard of anybody being successful doing this in Minnesota. Not that I'd heard anybody do it who failed, but just I might have been the first Minnesota person to give this a try. And by the way, Minnesota is not a consumer-friendly state. They've got essentially nothing, or at least anything that I could find in their statutes where they codified, like the Fair Credit Reporting Act or any of that. Unlike California, who's very consumer-friendly. So if you live in California, you get this done with no problem whatsoever. And even in Minnesota, I got it done no problem whatsoever. So anyway, after the attorney called, I said, all I really want is I want these deleted from my credit reporting, from my consumer report. Let's use the right terminology, because this is all consumer credit transactions, and it's important to use the right terminology. So we hung up, and basically it was just another waiting game. In the meantime, the courts had sent me 2 letters confirming the hearing dates for this small claims court case for both of them, both on the same day, kind of back-to-back, August 19th. So that was this last Monday. And so basically I've been waiting pretty much all this time. It was middle of last week that the attorney finally called me and said, "Yep, we have decided to settle." So they gave me all of the details of how that works. They, in one case, the collection agency, they are deleting and they are waiving the debt. So in other words, it's settled with prejudice, if I have that right. They can't come after me for those funds. The other creditor says they will, but they won't because it's charged off. They've already sold that to another collection agency. And that collection agency, and that was about a year ago or more, year and a half ago maybe, they have yet to contact me. They have yet to report anything on my bureau, on my consumer report. They have yet to do anything. So they're just like invisible. But they are the company. They're called Galaxy. They purchased the debt. And if I do run into them, if they do contact me, well, I know how to handle them now. So, long story short, it's settled. They're deleted. I didn't get any money out of it. I could have, and I know now that I could have. But the other reason why I felt like I didn't necessarily need the money is because both of these accounts were unsecured installment loans. One was for $40,000. One was for $7,000. I took those out. I immediately sent out negotiable instruments to set those accounts off or discharge them, which they dishonored. But I still had the $47,000 and got to use it. And so I figured, you know what, I'm $47,000 ahead of the game already anyway. So I didn't feel like I needed to put a potential crimp in this process or cause them to maybe want to fight me in court. I figured they'd be agreeable to the deletions because, what do they care? So that's why I didn't do that. But next time around, I've got 2 more that I want to chase. I'm going to get working on those here in the next probably couple of days. I've just been swamped at work. But I've got everything. The whole process that I did the first time, I took copious notes and basically created a step-by-step process so that when I do this again, I just follow my process just like I did the first time. And I think I can literally get 2 of these done in less than an hour, get them served, get them uploaded, and then, just do the waiting thing again. But this time I'm not going to settle for no damages. This next time I'll definitely be getting damages from them. So yeah, this was, I've been in this space for a long time, and I don't know how many people are on this call that have been like studying common law and negotiable instruments and really what's going on out there with these quote unquote debts that they say they're lending us money, but they're not. So I've been studying this for a long time, and this is really the easiest and most successful process that I have taken on myself, and also the least expensive. So I highly, highly recommend anybody that's looking at this to just do it. For $37 a month, these guys, I know they also have some upcharges for some assistance that they can help you with. It's all worth it. $47,000 disappeared. It's gone. I no longer owe those funds. As far as I'm concerned, they're discharged. So that's my story. And
Wow.
I'm sticking to it.
Thanks, Sam. We appreciate it.
Thank you. That's very good. Can we ask you a few questions while you're on the line?
Yeah, sure. Mm-hmm.
Chad, you want to go first, or you want me to?
Well, if you have questions, go ahead, and then I can open it up for the other callers if they have questions too. Sam, if you're available for that.
Yeah, I can stick around for a bit longer. Sure.
Okay. Go ahead, Donnie.
Okay. For me and for the rest of the listeners, those who be listening on playback, can you tell me what codes you put in the complaint for the listeners?
Oh, sure. I put in a lot of codes. I put in, it'll take me a little bit. 15 U.S.C. 1681A, 604A, 602A, 1974 Privacy Act, Section 5, Dodd-Frank Act, Section 623, 54 through 57, 15 U.S.C. 1681B, A2, 15 U.S.C. 1681C, A2AI, 15 U.S.C. 1581A, 15 U.S.C. 6802A, 18 U.S.C. 1028A, FCRA 623A7. I did actually get a Minnesota statute in there now that I'm looking at it. Minnesota statute 609-6765. I included the Fourth Amendment, Gramm-Leach-Bliley, FERPA, Fair and Accurate Credit Transactions Act of 2003, the Due Process Rule, the Hearsay Rule, and then United States versus Kosminski, 487 U.S. 931, 1988. So I believe that's it. I might have missed some, but I believe that's what we put in. That's what I put in there. And I could have put in more.
Pretty much. Yeah. No, we don't need more. We don't want to overwhelm you. You did great there, but I would caution you in the future that you can even simplify it. You don't want to give them a reason, an out, or they find one statute that they could use against you and get out.
Sure.
You did your homework, which is great, because anyone who's going to do this, like you did your homework, California is number one in consumer privacy law. So if you're in Pittsburgh, you're in Texas, you're in Nebraska, you got to do a little homework to see your court statutes, procedures. Every court is different. The language, some have, in California, we have 8 pages in our filings, small claims. I've seen some small claims filing with 2 papers. So do your homework, see what your court requires. Then try to find laws in your state that are favorable to you. In California, we have 3 very similar laws to FCRA laws, and most states don't. And I think in the future, every state will. I think they're just late coming to the party. I would recommend one thing when you go back and file again. I would take out the Gramm-Leach, the 1974 Privacy Act, because some of those lawyers will jump on that and make it a federal issue. We want to keep it in state court, exactly what you did. So I would, in the future, take out the Gramm-Leach in 1974 and try to keep it just LCRA.
So all of these are quoted in the course, and I believe we have made those corrections or those changes.
Yes. And everything is, updated. That's why I'm on the phone one thing tonight, too. There's always update. Things are changing. And we're trying to get better as we go along. We really appreciate that. As a little to your audience, go ahead, Sam. I'm sorry.
No, that's okay. I was going to ask. So you guys had provided exhibits, right?
Yes.
Which I had downloaded all of them and was ready to upload. But the only thing that ever got entered into this case was the statement of claim or the summons. I never uploaded one document as an exhibit.
Okay.
I thought I was going to wait until the very last minute.
Right.
And then didn't have to do that. So my question is, did you guys update those exhibits and remove those out of there?
Yes.
Yeah, we got. I sent him some. And we got new updated for tonight's call that he will have. I don't know if he hasn't posted them already. Okay.
Cool.
One more question. Do you think you can control your credit report in the future?
That was my question.
Do I think I can?
Oh.
Yeah,
oh,
so
yes.
If
yeah.
you get late and charge-offs in the futures, do you feel like that it's like, oh no, I can't handle this anymore? What do I do? Or do you feel confident that, oh, I know exactly what to do, no problem?
Oh my gosh, yeah. I feel like I feel like I have I don't know what I should say, but yeah, I have control over my credit report, my consumer report. Yeah, there's no doubt. Yeah, I mean it's very empowering. It's very empowering, I have to say.
Yeah. So if anyone has questions for Sam here, hit *6 on your phone. Right now, only questions for Sam. I know some of you have questions about other things, but Sam has to go here real quick. So if you have questions for Sam about his experience, hit *6 now. Otherwise, we're probably going to let him go. Okay, we've got a caller right here, 530. Go ahead. Area code 530. Just unmuted. Go ahead. Unmute your phone, too.
Oh, there we go. Sorry about that. My name is John Jacobs. I'm in California. I was just wondering, is there going to be a recording of this call so that we can get those codes? He said them so fast I started writing. I go, oh, hell.
Oh, yeah, don't worry about it. The codes are part of the course. So you don't have to write them down. So when you join the course, we have those codes that you need in the packet.
Okay, I missed about the first 5 minutes of the call. How do I get the course?
YouHaveTheRight.com.
Okay, I'm already a member that I pay $37 a month, but
all right, there you go. Go log in, and it's cash in on bad credit. That's the course. Little picture at the top. Yep, you click on that, and you go through all 5 steps.
Thank you, brother.
You bet. Okay, anybody else? Okay. Let's see here. All right, Rocky, go for it.
Hey, congratulations, Sam. I have a question. Well, maybe 2 questions, but quickly. What effect do you think those negotiable instruments had on this outcome?
That's a good question. I never submitted any evidence of those negotiable instruments. In both cases, I actually had not only a copy of all of everything that I had sent, but I also had the CUSIP numbers, the CUSIP report. So I know that they were hypothecated, they were securitized, but I don't believe that I ever brought that up to the attorney, and I certainly did not upload that into the case. So. Okay,
and the second part, the 10 days, you gave them 10 days to respond, which I'm curious, if you do it again, would you make any changes to that? Because to me, I feel like maybe that's a little bit risky running into like what I've learned about dishonor. I don't know. Obviously, you were successful, so would you make any changes in the future on the time frame you give them for the administrative process?
Yeah, right. Yeah, I hear what you're saying, and I might be a little bit more conservative that way, and give them more time to ensure that if we do run across a feisty attorney or something like that who wants to fight the battle, that I do have a proper administrative process. In the case of the 2 others that I want to go after, they're not impacting my mortgage licensing, so it's not as much of an urgent matter. You know what I mean? So, yeah, you're probably right. I probably would extend my administrative process give them 30 days, and then send a follow-up letter, a notice of dishonor, basically. I probably would do it that way, more than likely.
All right. Thank you very much for answering those questions.
All right. Thank you.
Yeah, and actually, one of them, I don't think I will, and the reason is that it's an auto loan. So I had discharged an auto loan in a way, and I'm not going to explain how I did that because I don't really want anybody else to do it that way because I don't think it's necessarily the right way to do it. But I had done it in such a way where their records for a period of time showed that the loan was paid in full, and they issued the paid in full letter and the title, the clear title. So I took that clear title, or the paid in full letter, and the satisfaction, I should say. They issued the paid in full letter and the satisfaction. I brought that down to the county, got my clear title. And then I used to pay for, I forget what it's called, but it's the service where you can have attorneys draft letters for you, whatever you pay, like $25 a month, something like that. I can't remember what it's called. I had an attorney send a cease and desist letter to that creditor, and this was a truck loan. It's for my Ford F-150, and in that letter, I had the attorney write, "You need to prove that this account was not paid in full." So anyway, I still have that truck, and that was over, that was a year and 8 months ago that I did that. So I still have the truck, and I have the MCO, the Manufacturer Certificate of Origin. So I have superior title on the truck. So for that one, and they have sent me letters since then. Like I got one about 3 months ago confirming that their records show that the account is paid in full. And the letter that they sent me was in response to when I bought the truck. I had gone all out on a maintenance package and gap coverage and so on. Well, as soon as I got my clear title, then I called the bank, or I called the insurance company for the gap coverage and canceled it and got refunded those funds. But then some months later, the bank itself sent me a letter saying, "Hey, our records show that you're paid in full, and we just needed to make sure we inform you that you can cancel that gap coverage." So I have plenty of evidence that this is a paid in full account. So I don't know that I would give. I think I would probably do the same exact process for that, because I would probably include the documentation that I have, the clear title, the satisfaction, the paid in full letter, and the letter that they sent months later confirming that it's a paid in full account, yet they're still reporting it as a charge-off. So I don't know how they're going to battle that. I'll bring that into court, and I think I don't think they're going to have much ground to stand on.
Thank you.
All right, Rocky. Thanks for the questions. Okay, so all right, Sam. I think that'll do it. I don't think we have any more questions.
Okay.
So
cool.
Appreciate you being here, and let us know how the rest of that works.
Oh yeah, for sure. I'll do that. I'll keep you guys informed.
All right, Sam. Thank you very much.